This lesson will cover civil rights from Chapter 5. What are civil rights? These are rights that are guaranteed by the government. The government carries a responsibility to protect individuals from discrimination based in inherent characteristics. These inherent characteristics include race, religion, national origin, and sex. Civil rights protections are guaranteed under the Equal Protection and Due Process Clauses of the 5th and 14th Amendments. They are also strengthened through the Privileges and Immunities Clause of the 14th Amendment. But of all of the clauses and amendments that are used to protect civil rights, the Equal Protection Clause of the 14th Amendment is the strongest connector. The Constitution imposes constraints and responsibilities on governments. That also includes government officials and employees, but it does not impose the same constraints and responsibilities on private individuals or organizations. The government is, however, allowed to create legislation that prevents private companies and organizations from infringing on civil liberties and civil rights. The Civil Rights Act of 1964 is one of the most recognizable pieces of civil rights legislation that you learn about in history. It prohibited private businesses and organizations from discriminating in their hiring decisions based on inherent characteristics. Other provisions to the legislation prohibit segregation in schools and public accommodations. It also prohibits unequal application of voter registration requirements. Civil rights cases are subjected to 3 different types of scrutiny tests. You want to be familiar with the distinction between the 3. Strict scrutiny is typically applied to suspect classifications. This is where we're looking at those inherent characteristics. So, is there discrimination based in an individual's race, ethnic origin, or religion? Discrimination can be considered legal if the government can achieve a compelling public interest, but this is much more difficult to prove when the discrimination is on the basis of inherent characteristics. The strict scrutiny test was used in the Loving versus Virginia case of 1967. I'm sure many of you learned about that in U.S. history, but the Supreme Court determined that laws barring interracial marriage violated the Constitution because there was no compelling public interest for which the government was responsible. Therefore, the laws were not necessary for compelling public interest. So today it is illegal to deny interracial couples the right to marry. The second test is the heightened scrutiny test, and its guidelines are used to determine the legality of gender-based discrimination. It is a weaker test than the strict scrutiny test, which makes it easier to justify sex-based discrimination. One example of where the government may see gender-based discrimination as serving a public interest would be with regard to women in the military not having the same opportunities in combat roles. The last scrutiny test is the ordinary scrutiny test, and it's the weakest test of the 3. It can prove discrimination is legal if the government can achieve a legitimate public interest. So, serving the welfare of the public, for example. This is a more common test when applied to age. So the government can establish minimum ages for legal rights, such as the right to marry, the right to get a driver's license, the right to purchase alcoholic beverages, or establishing a retirement age, like a maximum age for state judges. Okay, so we can recap these again. Remember that discrimination can be considered legal if the government can achieve a compelling public interest with all of these. It is going to be under strict scrutiny by the courts if it is discrimination based in inherent characteristics, race, ethnic origin, religion. It is going to be under heightened scrutiny of the courts if it is sex-based discrimination. But the courts may be inclined to recognize what they perceive to be serving the public interest. That discrimination based on sex might serve a public interest. And then the courts are going to apply ordinary scrutiny to laws that they may see to be reasonably necessary to carry out public interest or to be looking out for the welfare of the public. So having specific age requirements to be able to, again, get a driver's license or a marriage license seems reasonable. So again, ordinary scrutiny would be applied here. The text places quite a bit of focus on LGBTQ plus rights, mainly because that is the most prevalent group right now that is fighting for civil rights. Currently, this community faces the highest percentage of people who are victims of hate crimes. A hate crime is defined as a crime in which the offender is motivated by bias against the victim. Many members of the LGBTQ plus community also face intersectionality, which is the experience of multiple forms of oppression simultaneously. So, for example, one who identifies as being transgender, for example, may also be a person of color, may also identify as being low income, all working against them or working to oppress them simultaneously. Organizations that are fighting for LGBTQ plus civil rights typically fight for employment equality, housing equality, and marriage equality. Civil rights for the LGBTQ plus community were sparked in 1969 with the Stonewall Rebellion, which was the first collective community protest. The issue of marriage equality has been the focal point for LGBTQ plus civil rights, and there was a major turning point in 2015 with the Supreme Court case, Obergefell versus Hodges. And in this case, the court ruled that the right to marry is a fundamental liberty that should be enjoyed for both heterosexual as well as homosexual couples. Even though marriage equality was a huge win for the LGBTQ plus community, they still fight for other types of civil rights, including adoption rights, child custody rights, divorce rights, and property rights. The most blatant example of discrimination in U.S. history is slavery. Some of the earliest examples of the civil rights fight include abolitionists that practiced civil disobedience. This is the active but non-violent refusal to comply with laws that are morally objectionable and readily accepting the consequences. A strong example of this civil disobedience is the Underground Railroad. Abolitionists were bolstered when more attention was brought to the injustices of slavery. However, there was major pushback against the fight for civil rights at this time. We can look to the Dred Scott versus Sanford case in 1857. In this case, the Supreme Court ruled that the Missouri Compromise of 1820 was unconstitutional because the U.S. Congress lacked the authority to ban slavery in the territories. In the case, Dred Scott, who was an African American enslaved by a surgeon in the U.S. Army, sued for his freedom, arguing that because he had lived in both a free state, Illinois, and a free territory, the Wisconsin Territory, now Minnesota, he had become a free man and as such could not be re-enslaved when he moved to Missouri. The court ruled that Dred Scott was not a U.S. citizen, asserting that because of race, they were not citizens with standing to sue or the legal right to bring lawsuits in court. Although the Dred Scott decision appeared to be a victory for slave-holding states, it was also a pivotal, mobilizing moment for the abolitionist movement and did a lot to sway public opinion in favor of a war to prevent secession and to bring about emancipation. The South's surrender in the Civil War in 1865 led to the freeing of 4 million slaves and ratifying the 3 amendments to the Constitution, including the 13th, 14th, and 15th Amendments. The 13th Amendment ended and prohibited the institution of slavery. The 14th Amendment, which is what this chapter as well as the previous chapter is all based on, defined citizens as all persons born or naturalized in the U.S., and mandated the same privileges and immunities for all. And the 15th Amendment establishes every man has the right to vote regardless of race or servitude. It is not until later, the 19th Amendment, that is ratified in 1920, that extends this to women. After the Civil War, the establishment of discriminatory laws in the South were overbearing. There was a lot of pushback. This led to black codes, which were laws that were passed immediately after the Civil War by the South that limited the rights of free men. These were people who were formerly enslaved. Congress also sought to remedy those laws that were being passed in the states by passing laws that protected the rights of free men, but its effect was short-lived by the stubbornness of the Southern influence and beliefs. Jim Crow laws were also instituted. These were laws that required strict segregation of racial groups, whites and non-whites, for example, and they were practiced in both private and public institutions. You learned about this in U.S. history: de jure segregation, which is segregation mandated by law, but also de facto segregation, which is segregation maintained by practice. Jim Crow practices included white primaries, literacy tests, poll taxes, and the grandfather clause. Another pushback against civil rights included the Plessy v. Ferguson case. In this case, Plessy's attorney argued that under the Equal Protection Clause, segregation was unconstitutional. But in a vote of 7-1, the court ruled that segregation based on race was not a violation. They made this decision on the separate but equal doctrine, meaning that separate facilities by race don't violate the Equal Protection Clause if the facilities are equal. The unequal protections that came out of the separate but equal doctrine were made evident and brought rise to a stronger civil rights movement made possible by W.E.B. Du Bois and the establishment of the NAACP, known as the National Association for the Advancement of Colored People. The doctrine was challenged, and by 1950, courts ruled that segregating classrooms, dining rooms, and library facilities in higher education was unconstitutional. This change led to the challenge of public schools and segregation practices that were happening within them, and by 1954, with the court case Brown versus Board of Education, the courts finally struck down the separate but equal doctrine. The Supreme Court ruled in this case on the basis of the Equal Protection Clause of the 14th Amendment. The ruling stated that segregated schools were inherently unequal because they stamped Black children with a badge of racial inferiority that followed them throughout their lives. The ruling in Brown versus the Board of Education also paved the way for other civil rights fights, and the civil rights movement from the 1950s and 60s uses strategies that were first implemented during the abolitionist movement. And so we see the rise of boycotts. We think to the Montgomery bus boycotts, peaceful marches, voter registration drive-in and sit-ins, just to name a few. The civil rights movement led to two significant pieces of legislation you want to be familiar with: the Civil Rights Act of 1964 and the Voting Rights Act of 1965. The Civil Rights Act includes several provisions that mandate equality. The law requires equality in public accommodations, including hotels, restaurants, and theaters, as well as in employment and access to public facilities. Many civil rights leaders did not believe that the Civil Rights Act of 1964 went far enough in protecting African Americans in the South, because they had so systematically been intimidated and prevented from participating in the voting process. In some southern counties, less than a third of all eligible African Americans were registered to vote, whereas nearly 2/3 of eligible white voters were registered in the same counties. During the summer of 1964, thousands of civil rights activists, mainly college students, worked to register Black voters in southern states and were able to increase Black voter registration. Due to violent attacks on civil rights activists and citizens, Congress passes the Voting Rights Act of 1965, banning voter registration practices like literacy tests and other Jim Crow practices. As a result of the Voting Rights Act of 1965, registered voters among the African American community increased tremendously. The fight for civil rights still pushes forward, and this is sparked by the deaths of Trayvon Martin, Michael Brown, Breonna Taylor, and George Floyd. The Black Lives Matter movement began in 2014 and can be summed up in the following quote: "Our investigation indicates that this disproportionate burden of African Americans cannot be explained by any difference in the rate at which people of different races violate the law. Rather, our investigation has revealed that these disparities occur, at least in part, because of an unlawful bias against the stereotypes about African Americans." The Black Lives Matter movement is calling for legislation reform at the federal level, particularly within the Department of Justice. It also centers around the lack of value that is given to African American lives.